What is the area of your practice?
General practice, sir.
Acha, but how come you are interested about RERA?
I have a bit interest in that field. My dad is into land business.
Okay,
Yeah.
okay. CA Shashank Jain, our good friend from Mumbai, is he?
Yes, sir.
How are you?
I am good, sir. Very good afternoon.
Yeah, you're embarrassing me by joining this session.
Yes.
Who else? Karthik, Mahendra. Mahendra from Mahindra, correct? Mahendra Ganchi is from Mahindra and Mahindra.
Yes, hello.
Yes.
I'm audible, sir?
From Mahindra and Mahindra.
Yes.
Okay. Nice to see you. Good. Ram Babu is from? Yes, Ram Babu. Ram Babu from Bengaluru. Vikram. Vikram from? The session will not be more than 1.5 hours. If you are interested to learn something, I recommend you to be here fully so that you will get a value out of your participation. Otherwise, I recommend you switch on your cameras so that I can see you also. Akash, Ambika, Advocate Chitta Prasad is from? Abhishek Ji. From?
Hyderabad, sir.
Hyderabad. Okay.
Yeah.
Have we met earlier?
No, sir, this is my first time. Actually, I've been reading your articles in that Karnataka Federation, I think so.
Okay.
Yeah.
Okay. Good. Ajita Bhargavi from? Vishwas, can you who is this 23278609? Can I know? Your audio is not there. Many numbers are there. 23272502. Can you put your names, please?
Okay. Sir, can we start the session, sir?
Yes, ma'am. We can start the session.
Good evening, participants. It's my pleasure to welcome you all today webinar on RERA latest updates. Thank you for taking the time to join us for this insightful session. We will be exploring the most recent developments in RERA and their impact. I am honored to introduce our esteemed speaker for the day, CA Vinay Tyagrat, sir. Welcome, sir. About our speaker, CA Vinay Tyagrat, he is a fellow member of ICAI with qualification in BCom and LLB. Founder partner of Venu and Vinay Chartered Accounts with over 20 years of experience in taxation and business consulting. Since 2016, he has specialized in RERA advisory and compliances, gaining extensive hands-on experience over the past 8 years. A distinguished speaker, he has conducted over 300 workshops, seminars, and webinars across South India, addressing an audience over 50,000 participants. He has presented the prestigious platform including CREDI, NEREDCO, PBF, BRADI, ICI, Architects Association of India, Institute of Engineers, NLSIU Home Buyers Association, and many more. He has also shared valuable insight with RERA authorities and continues to be a key resource in RERA compliances and advisory. A regular panelist on Kannada news channel such as TV9, Raj TV, and Suvarna TV, contributing to discussion on taxation, RERA, and financial matters. His articles on finance and RERA have been featured in All India Radio, Kannada, Prabha, and Indian Express. He has served as a member of various technical committees of ICAI and is currently the treasurer of governing council member of Naredco, Karnataka. One unique aspect of Vinay sir is expertise is RERA combination of CA and LLB qualification, which gives him an expectational understanding of both financial and legal aspects of RERA. Let us all extend a warm welcome to this distinguished expert as he shares his knowledge on latest update in RERA. Over to Vinay sir.
Thank you, Vishwas. Thank you for introduction. It's a long introduction. Thank you so much. So let's start our session. I know that today being the middle of the week, and you all took the time to be here to listen about some of the new things about RERA and also latest updates, apart from what are the compliances from the beginning to the end of the project. Friends, a few are chartered accountants, few are from the industry, few are from the advocates, I can see from your name, okay, and few may have the experience and expertise in the real estate, probably RERA, and other than RERA also. I want each one of you to listen this session, considering that RERA will be there. RERA will be a regulatory authority for this industry. RERA will have a bigger role to play in this industry. Probably while I explaining, I will also say that how the information are connected from one department to other department, which makes it inevitable for every professional who advise a real estate client to aware about RERA. So that's the important aspect of this presentation also. Having said, I have very good friends of mine who is part of this today's session. Shashank Jain from Mumbai is there. Tarun Soni is there. Some of my clients, a part of my clients group is also here. Thank you so much for each one of you to be here in today's session. So having said, I'll just take about 2 to 3 minutes or maximum 5 minutes to look at that, the larger picture of this RERA. I know that even after 8 years of its implementation, 2017 to 2025, 8 years of implementation, but still I have to talk about the basics of it. Because probably how I can look at this is 1961 is the Income Tax Act. But if you open that also, now also we discuss about and the cases before the Supreme Court, the definition of an income itself. So the more we touch upon the basics objectives, every time we'll get a different perspective to it. Then look at what are the compliances under RERA required. We'll see that these are all the compliances from the registration, the financial management, and also the quarterly progress report and the annual audit, advertisement guidelines, and also I'll touch upon something about the completion of the project. Because RERA is a very small legislation of 92 sections, about 15 to 20 pages of the A4 sheet, that is all about RERA. But however, every aspect of the real estate is inbuilt in this. Every aspect of the real estate is coded through the RERA. And mere reading of this legislation, you may not appreciate that. Probably by practice, by looking into the practical aspects of it, one can really deep dive into the subject or the topic or the various provisions of it. Finally, I always say that Real Estate Regulatory Authority, RERA, is not a registration authority. It's a regulatory authority like a SEBI, RBI, or any other IRDA, TRA. They have an equal power of that in the real estate. and you know all that about the real estate, what is real estate constitutes. On the page, you can see that this is a huge number. Recent discussion and presentation of the presentation by our Honorable Chief Minister of Maharashtra. He said 20-25% of their GDP for the next year come from this industry itself. That will give a complete, a bigger lead to their state GDP. I'm sure that every state has a similar expectation, similar contribution towards this real estate. When they say real estate, it need not to be only the apartment, which is a residential. It may be a plotted development. It may be a commercial development. It may be a leasehold, everything. Apart from the government projects also constitute a real estate. New buzz is a rental housing. I'm sure that we all heard about the rental housing, but it's not going in a pace which the government has thought about it. I'm sure that there is a days to come about it, because now the alternative investment is in place. REITs are there, fractional investment is there. So all those things are something like gives the much bigger opportunity for this industry. And the 8% is what we have seen the last 2 years, and it goes up to 13%. It's a huge in terms of this industry. About 250 plus different industries are depending on that real estate. Second largest contributor to the tax to the nation. The second largest after agriculture for the employment, skill or the unskilled. It's a huge compared to any other industry, is what I can say about this real estate. And this is the objectives. Okay. So I know that we are aware that always any act comes with a preamble, and that preamble defines what is this act is for, this legislation is for, and we should keep that in the mind at all point of time when we read, when we advise, when we explore this RERA legislation. During my presentation also, please keep this in your mind: the accountability, the transparency, the professionalism, the information, the responsibility, regulatory mechanism, dispute resolution mechanism, and the governance. These are all the basic and the fundamental objective of this act to achieve. That means something was missing in this industry. With this act, they wanted to achieve these objectives. And every provisions of this act, every notification of the authority, every circular of the authority, every order of the authority has passed the test of these objectives. You go back and read any provisions of that, either of these things are satisfied or achieved by way of the one of the objective of the RERA. That is what is the important. That is what is the beauty of this act and legislation. Probably in my 24 years of my experience, I can say one of the beautiful legislation, one of the a clear act with the 20 pages is something which I have seen it. And the entire real estate transactions are captured, and the promoter cannot do anything without fit that activity or fit that into the RERA. That is what is the beauty of this. And I wanted you to listen the entire conversation, entire session, keeping these things in your mind. Then you appreciate. How many of you are first time listening to the RERA? Can you put it in the chat? First time? First time you are listening to the RERA? Yes, no? Put it in the chat. First time Ritesh is first time listening. Then put yes if you are first time listener to the RERA. Okay. Then who else? I can say about 2, 3. Okay. We heard it in RRC session, Sriram. Okay. Got it. Yes. Okay. The first time what you are listening to. Okay. Okay. Got it. See, why I'm asking these questions in between is I wanted you to be focused towards this presentation, because you have registered and you have taken, you wanted to listen to it. So I want you to be listen to me, and in between, if I ask the question, please remember and also say yes, no, okay, not okay, probability, okay. That is what intention of it. And the journey of RERA started from 2009 and it ended up 2017 because it is a central legislation. However, the land is the powers with the state government. So it took a decent of 8 years or 9 years for the government to convince all the state government and made this as an act and the bill and the legislation. It's very important. We have to see it. And this is the statistics of it. Okay. So when I say statistics of this is, as I mentioned, this is a central legislation where state is the supervision, coordination, regulatory mechanism is in the state hands. So in terms of that, that means to say that every state has to implement this legislation. That is an important aspect of it. Okay. So accordingly, out of 32 states have set up their RERA authorities, and of which regular 27 and also about 5 authorities are the interim authorities. And as you know that there is a authority and also there is a tribunal also. There are 28 states set up the tribunal also. And also they have operationalized the website. You should know that what do you mean by a website. Okay, why this is like probably this is the first legislation which I am also experiencing. Everything is online. So that is what is the government wanted to achieve it also. They made it everything is online. About 30 states made this as a website as a online from the application to the query solving to the approval to the appeal to the complaint filing, hearing. So everything they made so that the digital people sitting from anywhere and everywhere can access to it and also operate this. And also like this act has a authority has the something like the appellate tribunal, also adjudicating officer. They also appointed the adjudicating officer. So this is what is the statistics of pan India implementation. Generally, we read in our college days or the CA days, this act is applicable to entire India except Jammu and Kashmir. Even this act also in 2017 that was the law, but subsequently Jammu and Kashmir is also part of this act. Recently in 2021, authority was appointed. 2022 authority is there. I think few projects are registered in Jammu and Kashmir. So this is the some of the more statistics in terms of that. What do you mean by this? So where I'm getting this? This is published by the government, central government itself. They collect the data from the state government and post it in the public domain. This is the number of the projects which is registered in India, and agents are registered, complaints are registered. So now government has a data of what are the projects which are launching by way of registering with RERA. How many projects are having the timelines of 3 years, 4 years, 5 years, or whatever maybe. Now they know that how it is spread across. Second, third, how many of these are repeated promoters or the continuous promoters on the business or the builders in the business? Where are they presented? Which are the state they present it? And what is the timeline they're taking to complete the project? How big project they're doing it? Whether they're completing in time or not? Whether completed or not? So entire data is available with the government now for them to do the analysis of it, analytics of it. That is the beauty of it. All along, nobody has a data about how many real estate projects which is there in India. Unless somebody do a real survey like a JLL, Anarak, or somebody do a survey, nobody has the idea about these things. But now with this information, I'm sure that everybody, government will know that what is the growth of the industry, what is the growth of this business also is important to it. And complaints you have seen, disposed complaints, this is the beauty of this act also. Earlier, this complaint used to go to where? Anybody has anything? Put it in chat. These complaints between the buyers and the builder, allottees versus promoter, used to present where? Where they used to file a complaint?
Consumer code.
Either the consumer code or the civil law, right? So those are all the two things which had the option or opportunity for any of the customers or the allottees used to have it. Now, post RERA, Section 79 of the RERA is barred jurisdiction of the civil court to hear any complaint between the buyer and the builder. So, with that, always the complaints come before the RERA. If not RERA, it may go before the consumer protection, also consumer complaint. So now I know that how many complaints have come, how many are disposed, how many pending. This also gives you some statistics of it. To that extent, there is a burden on the judiciary before the civil court. That legal burden has come down. And the beauty of it, within 60 days, complaint should be disposed, and another 60 days, tribunal, 120 days or maximum 150 days. Maybe you take 180 days, the complaint is disposed completely. Next appeal is before the High Court. That means to that extent, there is a speedy dispute resolution is possible. Have you remember that in one of the first slide, objective is a dispute resolution. So can you see there is a dispute resolution mechanism is inbuilt in this. So that is the beauty of this act. And this is how is the act is flown. Act is a central act. States are empowered to frame the rules, notify the rules. States are there to administer it, regulate it, supervise it, and do the notification. But everything within the ambit of the act. Rules cannot bypass or beyond the act. That way, central government has taken complete hold on, control on what is the act all about it. Then the states also post the regulations. So regulations, we all know that like regulations are for the purpose of operation or working of the authorities. So regulations are also notified by various states. Notification circular orders from the time to times for the purpose of giving the clarity or the guidance to the or directions to the stakeholders of the industry. And the formats as may be prescribed. We know that there are various formats the authority has prescribed. So those things, this is the entire structure of in terms of how the RERA is structured. So this is applicability of that. I'll just rush through. Okay, this is RERA covers what are the aspect of it. Probably I will share this. If time permits, I'll come back and tell you. Okay, and as I mentioned that in terms of the requirement under the act is they require three professionals, which is the architect, chartered accountant, and the engineer. And for every withdrawal, these three professionals are important in terms of obtaining the certificate and withdrawal the money from the 70% account. Before that, I will just come to this 70%. What is this concept of 70%? I'll touch upon the 70% and again you will give the latest update on this also. Friends, we know that the real estate is something which is passionate about the funds flow, cash flow. If you observe that most of the real estate is depending on the cash flow rather than the profits at the end of the anything. The reason is there's a continuous cash flow in this industry. One project completed, next project started. There is a cash flow for it. Unless you complete entire project, you sell off 100% inventory, you cannot assess the profit of it. Invariably, 3 to 10% of the inventory would be unsold for a longer period, which may be 7 to 10 years or 15 years because of its vastu, size, ventilation, technical aspects. Their profits, part of the profits are stuck always with the company by way of the inventory. This money which collected from the allottees from time to time. See, one of the objective of the RERA is the accountability and the transparency. And you all know that how this industry used to operate before RERA and on RERA, post RERA, probably 8 years after RERA is given a complete transparency to us, at least to the larger projects or the larger developers. Every 100 rupees you collect, 70% should go to the RERA registered project account. This RERA registered bank account, where I can see in the RERA portal itself. That means to say there is a project account for every real estate project and 70% money should go to the same account. I'm sure that initially when they opened, many of were not aware that there is a 70, 30 or 100% to be opened. Now there is everybody is matured in terms of how the account to be opened. And for that, every state has given some guidance circulars. Like in Karnataka, we have a bank account direction 2020. Maharashtra has a bank account direction. Gujarat has a account direction. Most of the state has this bank account direction, how to open the bank account, in what format, and which are the banks. Which is the bank is a scheduled bank. We know that scheduled bank is as per the RBI schedule is given, and those are all the banks you can open the bank account, this project account. And most of the states now is particular this account, this bank account of the project should be opened where the project is located. That means if the project is in Mumbai, you should open the bank account in the state of Maharashtra with the home branch as a Maharashtra. Various time we see many of the client come, they operate from Maharashtra, they have a project in Hyderabad or Bangalore or Kochi or Chennai. They would have opened at the head office their RERA account, but while we filing the application, the authority say that you should have opened in the local place where there is a project is situated. That means, as a chartered accountant, you should, when you advise to the client, you should say that you should open the bank account in the place where there is a project is situated. That means, if the project is in Karnataka, open the bank account in Karnataka. Project is in Maharashtra, open the bank account as a home branch as a Maharashtra. The intention is, in case the authority wanted to attach this bank account, then they can attach easily. That is an important aspect of it. Friends, when the money collected from the customer 100%, 100 rupees, 70% will come to this RERA project account, and 30% go to a free account which can be utilized for any other purpose which RERA doesn't monitor it. But the 70%, once it go to the bank account, you should ensure this money is withdrawn using these three professional certificates. There is no exception whether authority ask you to submit this certificate or not, but it is the responsibility of the promoter, that is a builder, developer, landowner, whomever you call it. They have obtained the certificate and submit in case department ask. If they don't ask it, probably they can retain themselves. That is an important aspect of this register, this bank account. As a chartered accountant, you should guide. You should guide to your customers, your builders. This is the account, and you should use it. If you do not use it, then it becomes difficult for you to comply with the Section 4 to LD of the RERA Act. This is a fundamental. This is one of the foundation to this Act itself about this. You may have asked, sir, what is the 70% amount I should deposit it? Many a time, 100 rupees plus 5 rupees GST, I will collect it. I'll collect 100 rupees. At the end of it, I may collect the advance maintenance charges. I may collect some of the charges towards the power charges, power connectivity charges, water connectivity charges, or clubhouse development charges. So these are all the different heads the promoter generally collected. So should I deposit everything in this account, or only the money which is entered into the sale agreement? Because sale agreement also will have all these uh, uh, values which is mentioned. So with this, the authorities has given a clarification stating that any of the pass-through charges need not to deposit into this account. That means your GST is a pass-through, your BESCOM deposit may be a pass-through, water deposit may be a pass-through, your clubhouse deposit may be a pass-through. Clubhouse development charges is a income, but a clubhouse deposit may be a pass-through. Those amount need not to deposit in the 70% account, and they can deposit in the other bank account other than this. So you should remember, as a professional, these three professional certificates, that is the architect, engineer, chartered accountants, are very much important to withdraw the money from the RERA account itself. I know Tamil Nadu don't insist. Tamil Nadu authority don't insist this certificate. However, bankers are required on this. The latest update from the bank is, I know that Axis Bank or Yes Bank has made an inbuilt application. They made an application in the software itself, capturing the professional details along with the limit of withdrawal itself. So when the limit is exhausted, they're asking you to get the new certificate for the withdrawal. So these are all the few latest important aspect with related to the only the certificate. Friends, we have seen various professional friends are giving the certificate in a very casual manner. Please note, it has been held in couple of High Court and Supreme Court judgments stating that chartered accountants is the responsible to allow the withdrawal of the money of the allottees. That means to say this is the allottees money. Because of my CA certification, they are withdrawing the money. That means I should be more diligent in terms of this money of the customers are going through the project only. We should know what is the project cost, what are the project expenses, whether those project expenses are part of the initial registration. Only those expenses you are allowed to withdraw from the 70%, not anything other than the expenses. When I say project expenses, it's a purely a project expenses. Project construction cost, not the marketing cost, because marketing cost is a selling cost. It is not a construction cost. Many of time we encounter chartered accountant without understanding these basics. They also would have been allowed to withdraw the marketing cost. Marketing cost should go from your 30% account, not from your 70% account. Keep those things in the mind while you issuing the certificate, and ensure that information which is provided by the customer, that is a builder, is documented well, properly, and issue the certificate, because these certificates are with the government authorities, that's the RERA. And we also come to know that GST departments are writing a note letter to the RERA authorities. Please send a copies of the CA certificate which is issued during the quarterly update or annual audit. That means to say that other authorities, other agencies like a RERA, sorry, income tax, GSTs are also interested in terms of collecting this data from the RERA to claim any of the additional um, what I can say is the information through this, because RERA certificates are very dynamic certificates. Every quarter on quarter, we issue this based on the books of accounts maintained by the promoter. So this income tax, GST, they get a complete picture on 18th month or 24th month. So, but in RERA, it being the dynamic, they can collect the information on a regular basis. As a chartered accountant, again, I am insisting, ensure you understand RERA, at least the certification part completely before you issue. Friends, don't think that I'm scaring you. I've seen the cases where authorities have issued the summons to the chartered accountant in case of a project which are delayed, where customers are made the chartered accountant as a party to the complaint, asking them to come and explain how the funds are moved from this bank account having collected from the customers. That is a very important aspect of it, because chartered accountant and engineers, chartered accountants, so engineer and architects may only give to an extent of the construction, but as a chartered accountant, we look into the books of accounts and issue it. That's a very important aspect of it. Again, carpet area, objective of the carpet area under RERA is to bring the standardization, like a liter, like a kg, like a meter for a cloth, and a kilometer for the distance. What was the measurement for a real estate earlier was probably built up area, saleable area, super built up area. Ultimately, nobody was understanding what is this jargons, how do I measure as a common man or a buyer. So with the introduction of the carpet area in RERA, now there is a standardization across India, from Kanyakumari to the Kashmir. I have the same practice of measuring this unit of measurement of my real estate transaction by the carpet area, and also carpet area to super built up area or the saleable area. One can see that two-bedroom house 1200 is the saleable area, means say 800 may be the carpet area. That means he has loaded one third of super built up area to the carpet area, or 50% of the carpet area loaded as a super built up area. That means to say I have a well informed information to the customer or even to the builder that okay, what is my loading, how I am loading it. So, and carpet area is adopted through across other statute like income tax, GST, are also adopted the definition of a carpet area from the RERA itself. So, at the all the most important for us to understand the RERA, because if you are practicing GST or the Income Tax Act. As I mentioned, the first entry into the RERA is the registration. When should you register? The project should be registered before marketing, sale, advertisement, invitation, or collect of any advance from the allottees in the project. So project should be registered with RERA, generate the RERA registration number, then only the product can go to the market. Before RERA, people used to launch it, pre-launch it, pre-launch it, and they used to collect it, and later they used to even get the joint development sharing agreement or the plan sanctions or NOCs. No, now RERA clear. If the product what you're going to deliver is ready with the fundamental aspect of the plan or the action points, then you come to me, I will give the registration. If you should be clear that it's a 2 acre land, 100 number of apartment I am building it, G plus 5 floors with 100 car parking. You should have clarity with all those things. Then you come to me, then I'll give the RERA registration. Shashank ji, you raised the hand. I want you to put it in the chat so that I can take the questions along with my presentation. And end of the session, I can also take some of the questions. Friends, you can all start putting your any questions in the chat. I will also try to address while I mention it. Okay, so that is my request in the interest of the time. If you read section 3, requirement of a RERA registration, section 4 is the complete details required for the purpose of RERA registration. I'm sure you will be astonished to know that the information which is required for the purpose of RERA is a huge. If you want me to take in simple words, if you wanted to avail the housing loan with any of the banker, what are the details document the housing loan company or the bank will insist, same details they should give it. Plus background of the promoter, history of the promoter, completed project, number of projects ongoing, group entity in case of a SPV. So these are all made as part of the project registration itself. And in Karnataka, 100% details are collected at the time of registration. And if I say that if you go through the RERA website, you can assess which is far, far more better information the promoter or the builder can give it to the customer. To that extent, the information available in the public domain. And apart from that, you have this estimated cost, you should give it. How to arrive at the estimated cost? As a chartered accountant, I can support my promoter or the builder to arrive at the estimated cost through the engineer and the non-engineer information. Before RERA, nobody aware except the top one builder, top category A builder, category B builder used to only arrive at what is the costing of it. But now it is becomes inevitable. Everybody should show the costing at the time of RERA registration itself. That means to say that 1 acre of land, 100 apartments, 50 crores is my project cost. Very clear about it. Somebody is coming out with the same 1 acre, 100 apartment, 60 crore rupees of project cost. There is a 50 crore for 100 apartment, 60 crore for my 100 apartment. There is a cost which is already available in the website. It act as a multiple transparency for a customer. I know that I'm buying in a project where 50 crore is the project cost. I'm buying in an apartment, 60 crore is the project cost. That means my price is better than or expensive than this. So what is the specifications which is there? So entire information, who is your project architect, who is project engineer, who is your project chartered accountant, everything is available in the RERA website. So section 4 mandates it. It is the mandate of the promoter to submit all the document for the purpose of approval. Having received the approval, this information goes and the portal of the authority always, and which is amenable, which is can be open and see by any of the public. This is the beauty of it. Can you have you remember the definite objective of transparency? This is to achieve the transparency. This is to achieve the standardization. Like this apartment is 100 apartments, you need this information. Another fellow need the same thing for 100 apartments. These are all the important aspect which is important to that. So Shashank sir is asking, section 3 says no promoter shall advertise, market, book, sell or offer for sale. Sir, so can you throw some light where I'm registering the project with zero FSI? There is no sale component on the date of registration with RERA as per approved plan RCC. What is zero FSI, Shashank? Can you just say?
So my plan which has been approved, it is only up to the pre-plinth level where I do the excavation work, and there is no sale component or no sanction float as of now. Because once I reach a stage, then I'll make the premium payment, and then the authority will issue me the flows.
Higher floors. Probably, Shashank, this problem persists only in Maharashtra. Okay.
I am from Maharashtra, sir.
Yeah, you take the IOD and also you also look at that the potential construction, potential FSI. Okay, Maharashtra is a completely different in terms of that. I'm sure that like you have a something only the no FSI, and if no FSI, how do you sell it? Simple.
But the intention of Section 3 is I need a RERA registration before advertisement.
Exactly.
So what I'm telling you, I want that my presence should be there. So that's the reason I'm taking RERA registration. I'm putting my holdings and everything. I'm not selling. I'm just
Perfect.
my presence.
Okay. Then what you should do is you keep marketing, you keep advertising. There is no sale component because there is no product for you sell at this point of time. When you get that FSI or when you buy the FSI, okay, obviously you should go for the modification of it. You should go for the modification of it. When you go for the modification, modify the plan, you get the inventory for sale in the market, then you market and sell it. Further, you wanted to add further FSI. Certainly, you have to disclose that to the existing allottees. Take the 2/3 consent under section 14. Further, you go back and load that and do that. So that is what is the important aspect of it. So
Sir, in other states, there is no such FSI concept, no?
now we have FSI concept, but only thing is zero FSI. I can't sell it. At least I should have something for me to sell now. Okay. Maharashtra, because Maharashtra is far away in terms of the real estate. That too, what you're seeing is a redevelopment. What I'm
Right.
trying to tell you is for the redevelopment, because that's only in the Mumbai is the major one what you see it. Otherwise,
Yes.
fairly it is
Because
something
recently,
come with the inventory.
recently, what has happened in RERA,
Yeah.
they have stopped giving RERA registration to zero FSI,
Okay.
which was there till I can say 20-25 days back. It was allowed. Now they have stopped suddenly with no circular, no order, nothing, and now around 800 projects are hanging.
Understood. Probably representation should be given. See, even they also have a valid thing because you marketed now. Tomorrow, I don't know when you come back to me in terms of the sale component. Even many a time, out of this 800 will not look into the FSI at all. So
Understood.
why are you creating that burden on the entire ecosystem? So when you have some inventory in your hand, please comment. You take the registration. Okay, till that don't
Yes.
market it also. See, there is an intention behind this. I'm sure that this is how it is goes. Okay. I,
Okay.
sir, if developer is not delivered project as per RERA registration certificate validity at the time what customer has the right to do. Obviously, Mahendra ji, he can go and complete it and he will eligible for the delay compensation. Is what is that? Developer has misused the fund for any other purpose and project struck hold other than whether customer can. Yes, obviously, because the project is struck, his product is not delivered. Obviously, customer can go back and file a complaint in accordance with to claim the delay compensation and also any other relief, including the refund of his money is possible. Section 31 as the filing section, he can file a complaint, and under section 18, the authority will listen to that. Yeah. So registration is a first entry into the RERA. From registration to the completion, you will be with RERA. See, the beauty of this act is like you take the building sanction plan approval from the planning authority in case of Maharashtra MADA or something, okay, or DTCP. And what happens in case if you take the approval, then you'll go work only under completion certificate to obtain or occupancy certificate to obtain. You take any approval or NOC from other department, you go back only on the final NOC. But with RERA, the moment you register with RERA, you are with RERA. till you completion, you have to be update on quarter basis, annual basis, and also any changes in the specifications, the product, and the structure. Then you should update that. So that is important of it. It is not that I've registered, I'll be away from that. No, RERA is not a registration authority. RERA is a regulatory authority which is having a power to administer, supervise, regulate entire project. So that is what is important aspect of it, because many a time people say that, sir, RERA is only a registration. Now what else is there? No, every action of your is as your RERA has a role to play is important. It and RERA compliances. This is a generally a standard RERA compliances. Once the registration is completed, you file for the quarterly progress report, and each state has given from the end of the quarter either 7 days or 15 days or 21 days, depends on the state. They have given a time, and within that time you have to file your quarterly progress report. Probably in subsequent slide I'll show you what are the information generally they expect, and also what is the act talk about it. Then also your account should be audited. Audit of accounts of the real estate project within 6 months from the end of the financial year. That means to say that it is 31st January, 31st March. 6 months is about 30th September is the time where you have to complete your annual audit submission. That means audit should be carried out and the report should be submitted with RERA. That is the one more thing which is important. And also change of bank account or any changes related to the registration, you have to go back and update it. It is not that once you obtain the registration and you can keep changing whatever you want it in the registration. No, any information which undergoes change in the registration details, you should communicate back to the RERA, make an application and make it necessary changes or amendment, including your engineer and a chartered accountant. If you read the bank account directions, which many of the states have given, they very much clearly stated that if you are changing your chartered accountant, take the prior approval. If not the prior approval, as a professional, I should guide my promoter, at least communicate and inform them we are changing the chartered accountant from this chartered accountant to another chartered accountant. That is an important aspect. And when I say that change of separate bank account, any changes to the registration, what could be the any changes to the registration? Bank account may change, your professionals may change, your estimated cost may change, your promoter address may change, your directors may change, mail ID may change, mobile number may change, number of inventories may change because of modification plan. So information which is available in the website as a registration, if that is goes change, then you have to go back and file the application for the changes. So this is also important, because many a time once we apply for registration, we just keep filing the quarterly update and also annual audit without looking at what is there in the registration details. So most of the state has this information on the online portal itself. You make the changes necessary on that. So developer has misused the fund for other purposes, then yeah, I told the complaint it. And does the authority validate project cost at the time of registration, assuming the developer has inflated the cost, mentioned higher cost, and at the time whether the land contest the what? Okay. Does the authority validate project cost at the time of registration, assuming the developer has inflated the cost? I'll just, for the sake of everybody, I've taken this from one of these I'm not disclosing who has posted it. I hope who has is posted this message, is it okay to post in the public domain? So I posted it, okay, without disclosing the name. It's a very interesting question. So at the time of registration, say I put about 50 crore rupees, 10 crore towards the land, 40 crore towards my construction. So total is a 50 crore rupees. Now, these authorities are checking this valuation, this information about 10 crores and 40 crore rupees. I do not know. Every authority is checking, but few of the authorities very much aware that this information what they are giving should be a reasonably an estimated one. You can't say that for 10 apartment I'm putting 100 crores. Maybe correct 100 crore rupees because he is giving the super luxurious ultra high net worth project in opposite to the Mumbai Sea. Okay, plausibly. But then they will raise a question, what is this 10 apartment? How this 100 crores is arrived at? you may reply to that. It may not be the answer for everything. So that is the reason many of the authorities are taking the certificate from engineer stating that the BOQ work order. How did you arrive at this? And also based on that, chartered accountant is adding other cost other than the construction cost, maybe a professional cost, interest cost, administrative cost related to the project, arriving at the project cost. So as a chartered accountant, while I issue this certificate, I should be aware that what is this project cost, how the project cost is arrived, then you are on the safe hand, because you just can't fill the information like a fill in the blanks and submit it. You should have at least some fair idea, a fair discussion with your promoter. How did you arrive it? What is the background and what is the backup of it? Then you may be safe in your hand. And if that need to change, yes, you have to approach. We have to approach the authority, and the authority may hear you during the hearing. They will allow you to change. That's the process which goes on. Next important aspect is your penalties are levied based on this project cost. We have a super case. The promoter, while filing the application, instead of the mentioning 4 crores, 0 has added, it has become 40 crores. This builder has not filed the annual audit report. Authority has levied 0.5% penalty. They levied a 0.5% on 40 crore rupees, that is a 20 lakhs. Otherwise, it would have been only 2 lakh rupees. Now, this fellow has to run around, say that it is not the 40 crore rupees, sir, it's only 4 crore rupees, sir, but levy of penalty is made on 40 crore rupees. Till that promoter didn't know that, the builder didn't know that in the website it is showing 40 crore rupees. Till he received his penalty application, penalty notice. So that is what is important. As a chartered accountant, we are good at numbers. We have to have eye on this information before it goes to the RERA registration. You may not indulging, you may not advising your client for the RERA registration, or you're not filing, but you should tell him that before you file the application for RERA, please get the information vetted by me, because I am your chartered accountant. Tomorrow it has a direct impact on my GST, my income tax, my accounts, my audit, your funding, or whatever maybe you call it as. Okay, this is the important aspect of it. Do I need to register even if I plan to sell after completion of the project? Mamata Bharakthia. Bharakthia. Answer is yes. Answer is yes. Answer is yes. Because as I mentioned, RERA is not a registration authority. RERA is a regulatory authority. Whether you sell after completion or whether you sell before completion, RERA registration is a mandatory. But in Maharashtra, we have read that there is one circular is given. If the project received the completion certificate, RERA registration is not required. Probably the authority will soon withdrawing that notification because it is not in accordance with law. And similarly, Rajasthan has passed the order. In case of a completion project, RERA registration is not required, but however, the NOC or the confirmation from RERA is required. So in Rajasthan, what SOP has been done is, in case of the project receive the completion or occupancy certificate, submit all these details to the RERA. RERA will look into that, and project is completed, including the occupancy certificate you submit, including the fees you pay it for the equal to RERA registration. They say, yes, this project is completed, do not require a RERA registration, but it has to go through the same process equal to a registration, is something which I say that. So Mamta, hope I have clarified you. Next, is the interim order passed on settlement or reconciliation process is appealable? Madam, I don't know. It's a legal question. Maybe appealable. Okay, I don't say it cannot be. It all depends on the facts of the case. It may be appealable. In that case, when does registration have to be done? Can I register after project completion? As I mentioned, Mamtaji, Section 3 is very clear. You have to register the project before sale, advertise, marketing, collection of money, inviting the person. If you have not done any other any of these activities, the moment you think that you want to do these activities, come and register it. That is what is important aspect to it. So these are the major compliances throughout your project is you have to go through that, and it has to be do it in a diligence manner. It is not just you put some numbers there and you will be away from escape from that. So as I mentioned, QPR, we fondly call it as quarterly update, quarterly progress report. What is there in that? Where is the provision? Section 11 mandates the promoter of the project should file the quarterly progress report in a way and manner as per the rules. Rule says that due date rule says what is the information to be filed. Generally, the information about this quarterly update is authority wanted to know what is the progress of the project, how much is the movement of your inventory, sale, unsold, collection of money, whether the money is deposited or not, any loan is taken on this project by encumbering the project, any litigation and the land has been arranged during this quarter. This is what is important aspect of it. As you know, as we all know that chartered accountants are the masters of the compliances in any compliance for that matter. This is one more compliance. For registration, many others will do. Advocates will do, engineers will do, chartered accountants will do. Your data entry person in a internet cafe will do. Many people are doing it. I don't know how they are doing it. That too, how the builders are relying on the people who don't know RERA. They're going and giving information with the stating that it's a small amount. The fees is very competitive to them, and they are participating. Very important for the promoters. I'm telling you, if your client is a builder or a developer, you should tell him that the information which goes into the RERA portal is very critical, very crucial. That depends. That is the fundamental for your entire project. Every information you have to validate it and verify it, then only you should submit it to the RERA portal. We have seen various builders, they have given this to the data operator, data entry operator in the cafe, internet cafe. That fellows are doing for 10,000, 20,000 rupees for the registration. I don't know what information they will be of the experience of it, expertise of it. So remember, this information which goes as part of the RERA registration is there for the entire project. On that, every quarter, where you have traveled, how you have traveled, and what is the project development, what is the percentage of completion, what is the professional certificate, what is the borrowing, how the borrowings are also utilized. Maharashtra, not Maharashtra, Karnataka, and few states specifically said, if you have taken the money for the purpose of this project, this money should be deposited in the RERA account only. You should deposit the money in the RERA account only. That is why if you see in the RERA CA certificates, in the RERA CA certificate, just can you hold on, somebody's. So if you see the CA certificate, can you see the principal and interest repayment? All along we were thinking why the principal amount component should come to my CA certificate as per the cost. That principal is nothing but because you deposited money in the RERA separate account, you are eligible to withdraw from the RERA separate account based on the out of your sale collection realization. That is why that premium principal is there in the RERA certificate. So CS, the authorities now say that you should deposit this borrowing of the loan for purpose of the project should go to the same project, not on any other project. Can you see that how this industry, how the real estate is transforming in terms of the funds utilization? Friends, prior to RERA, funds borrowed but utilized for some other project. Actually, even bankers are not permitted to sanction any loan in the name of this project and allowing the promoter to withdraw for other project. That is also now not permitted because bankers are made responsible in terms of not doing their due diligence as part of it. And the unit reserved for landowners to be classified as sold or unsold in QPR. A very good question, Purvi. I'll just tell you, What is registered is a project. Always we should remember what is registered is a project. Project has share belong to the landowner, share belong to the developer. If you register the project of your share, landowner share, then you need not to report. If you registered the landowner share as part of your project registration, yes, you should disclose the sale or sold or unsold by collecting the information from the landowner, including his money should be deposited into this separate account only. That is the intention of the act. Probably Maharashtra has a different view about it. They need not to, they have to open separate account. Consider if they have 10 landowners, how do I separate, deposit into the 10 different landowners, and how do I collect the information from the 10 landowners and report to the RERA? That is the question. Probably those things will all be resolved over the period, because as I said, it is a 8 years of RERA, 3 years of 2.5 years of COVID is gone. Initial 2-3 years is of new legislation to everybody. Possibly post 22 only, post 23 only, effective implementation, effective compliances, effective looking forward for RERA in the real estate is what is happening. Quarterly progress report is very important, because this every quarter on quarter you update it. This information can be obtained by your income tax department, can be obtained from your GST department. Probably I can see various GST authorities are writing a letter to the department stating that this promoter has so much of ITC. However, collection are sold shown as less. Please give us the CA certificate which he has submitted, or the quarterly progress report he has submitted during the quarter. So that is a weapon or a tool in the department. So you as a chartered accountant should not become a victim or a scapegoat for it. So you should ensure that you verify books of accounts, look at the transaction, then only issue the certificates. QPR is very, very powerful, very, very effective tool in the hands of the all other authorities, including the RERA authority. So as a chartered accountant, you should be clear about what you are certifying as part of your quarterly update, and more so what is that you're advising to your promoters or the builders. Friends, I'm sure that most of the developers or the promoters are nice. They will listen to what we advise. But we are shying ourselves in terms of advising to the builders or developers. Probably he'll say that, sir, I don't know anything. You do it, sir, on behalf of me. You file the compliance report. You file the quarterly update. I don't know about anything, RERA. I'm here to do the business. You are here to support me. Please tell them, okay, fine, I'll take up. And for that, you should know about RERA before you advise it. That is what is important. Next important aspect is the audit under RERA. What do you audit? Already we have income tax audit, some sort of GST audit, we have companies act, LLP audit, many things are there. Then what is this audit? Audit under RERA is a project audit, not your entity audit. If you have an entity having chocolate business, real estate business, I'll do real estate project. I have a project A in Mumbai, project B in Karnataka, project C in Hyderabad. I'll audit only the project related. Project by project, I should audit under RERA and submit the report, which is prescribed in the format most of the state, Form 5, say Form 7 in Karnataka, something in other state. But what is there in Form audit report is what is the money collected during the year and since the inception. What is the money incurred during the year and since the inception. This is the two major paragraph. And also further it goes on says that the promoter, I hereby certify that the promoter of the project of ABC Private Limited is in compliance with the provisions of the RERA Act and the rules or the notification which is issued by the authority. This is a dangerous thing, because they ask only two specific and general in a paragraph. Then what is that? Is in compliance with the provisions of the RERA Act or the rules. So that means to say you should know about the provisions of RERA, various provisions of RERA. If you do not know various provisions of RERA, what certification you're issuing may be wrong. I'm not telling it will be wrong, may be wrong. In case of a difficulties, it becomes difficult to change. In case of a project which is stuck, project has some problem, maybe a genuine problem, there would be a legal issue, there may be a NGT issue, there would be a government problem, then you will be under a mess in terms of this. The question which I received, land is already mortgaged to society before RERA registration. His bank RERA account is at private bank. See, private bank is okay, but the private bank should be a scheduled bank, number one. Land is already mortgaged to society before registration. I'm okay with that also. But as long as this money is used for this purpose of the construction or development, that is what is important. So RERA annual audit is important for you to understand and appreciate in terms of why this audit has brought, because they wanted to see the money utilization, money incurred for the purpose of project, including your borrowing funds also. Karnataka, I think Maharashtra, Gujarat has a detailed audit certification, which gives a good input to the professionals about what information to be given. And my recommendation is you buy some of the books which is published. And one of the good book is the Taxman publication. I am also one of the author. About 100 authors have written that book. One of the good publication. And Mr. Ramesh Prabhu, one of the senior chartered accountant who always talk about RERA, is also a co-author, editor for that. Like you have another 50 to 100 chartered accountants or advocate who have contributed to this topic, this book. Please go through that and read that. Worth buying the Taxman publication. Very detailed. It's a professional perspective. Next is about section 12 about the advertisement. This is very important because we see that this real estate spend about 6 to 8% on the advertisement itself in the sales. So 6 to 8% of their collection of the sales is towards advertisement. It's a huge in compared to any other industry. And the value wise also huge. Value wise also huge. So section 12 talks about veracity of the advertisement. What do you mean by veracity? Can somebody post it in the chat? What do you mean by veracity of the advertisement? That means the advertisement should be a truth, correct? Truth. Advertisement should be a truth. It should not have any false information. But however, how many of you observe what is there in the advertisement? Is that the truth? Is that delivered? And very difficult to assess. Even the builder themselves may not be able to deliver what they advertised about 4 years back because of the various challenges. But time to time, one should look at that what they're advertising. Is the intention me to deliver it? Intention me to complete the way that it is delivered is what I say. Important, okay? And the advertisement itself, I can talk about today, how to advertise. And many of the authority has given the advertisement guidelines. The prominently visible, section 11 talks about advertisement number, which is displayed on the every advertisement, whether it's maybe a printed media, social media, on the TV, on the FM, on the radio, on the phone, SMS, it should have a RERA registration number, which is prominently visible. What is prominently visible is where you can look at Karnataka has given the guidelines, how much prominently visible. Maharashtra has given. Recently, UP also has come out with guidelines for the RERA registration. So, advertisement for RERA projects. So, very important for us to understand and also advise the clients. Then come to this. So, we have seen the registration, quarterly updates, annual audit, any changes during the project that you need to do it continuously till end. Advertisement guidelines you have seen. There is section 14 called modification. Any changes to the registration of the project of which involve any modification relating to the building sanction plan or the specifications in the project, you should go with the 2/3 consent of the allottees, come back to RERA, make a necessary application for modification. So this is the life cycle of the project. At the end of the project, you come to the completion. Many a time, what do you mean by completion? Where is this completion is specified? RERA doesn't have the completion completion says. They say all that, but completion, what do you mean by a completion? Based on the practice, based on the experience, few of the states come out with their own way of saying that this is what is a completion. So they says about it. You file the occupancy certificate or a completion certificate with the professional certificate with the bank statement and the sample agreement of sale, sale deed, and the CA certificate, architect engineer, project is completed. So submit the project completion. Karnataka has come out with companies under Form 4CC, which has gone beyond what is really required in terms of stating that a chartered accountant is certifying that the project is completed in accordance with the brochures or the marketing materials, collateral they have posted it. Where do I have competency to verify all those things? But still it is part of the Form 4CC. It further goes and says that whether association is enabled, formation of an association is enabled. That means to say I should go back and check what is the formation. If association is formed, what is the registration number? If so, what is the money collected from them as part of as a corpus? Whether it's a refundable, non-refundable. If refundable, how much is the amount? When are they refunding it? And even Gujarat has taken one more step, stating that you open the association bank account, deposit this refundable deposit into that association account, give me a copy of that, then I'll say that this project is completed. So this to this extent, the authority is insisting, but few authorities are little slow behind in terms of what does this say completion of the project. Somebody is posting a question, sir, authority is issuing the completion certificate. No authority is issuing the completion certificate. At match they publish in the website stating that this is the information stated by the promoter, the project is completed 100%, which is available for the public to view it. And also very important, when you say association formation, there is a various Maharashtra is having clarity on the association formation. Other state has little challenges. Even Odisha has come out with the Association Form Act. Tamil Nadu in 2022 Act 2024 rules are there, but it's not completely implemented in the truest manner, which really required that. So that is what is the important of it, and it's part of your RERA now, because Section 17 talks about conveyance of the common area to the association, handing over of the asset to the association. Very, very important aspect. The minute detail of the real estate is taken care. If you collected about 1 lakh rupees per unit as a refundable deposit, then where is that money? How do you refund it? When do you refund it? Association. Those information to be given. You collected 12 months of advance maintenance charges for the maintenance of your project. You spend 6 months. Where is another 6 months? How do you give it to the association? So these are all the various aspects as part of the registration which they're there. Association or Act or KAOA. Mamta madam, I am sure that you are part of Karnataka. Understood. So KAOA is something which is the act for the apartment ownership, because it's a very specific act for the purpose of registration of an association, or I can say deed of declaration. Karnataka Apartment Ownership Act is a specific act. But however, there are challenges being the AOP, Association of Person, which cannot hold the land, which cannot be sued or sued. That has a different opinion on it. But certainly government will come out with the new legislation to that. We'll see that part of it. So this is a big picture. So we are 5:15, probably at another 5-10 minutes, I'll try to close it. Then I can take all your questions. But one request is all you should switch on your videos. Entire thing has been there in this act, section 3 to 8, registration, rejection, extension, revocation. 9 and 10 you have the promoter. So 9 and 10 about the registration of the agents. 11 is about the 11, 12, 13, 14, 15, 16, up to 17 is about the promoter. 18 is the complaint, 19 is about the allottees. This is how it is completely there. If you have not read the act, I invite each one of you to read up to section 19. And it's very, very good, very small. 19 sections, about 5 pages, you can read within no time. So entire thing is captured. Then how the authorities function, how to file the complaint, how to file appeal. For section 43 is the appeal, how to protect the interest of the allottees, consumers, is completely there as part of this RERA. Then what happened to the penalties? Friends, do not venture, do not even think about penalties under RERA. what generally we see is about 500 rupees, 1000 rupees, 5000 rupees, 50,000 rupees. Under RERA, always penalties is based on the percentage of the estimated cost of the project. Not registered, advertised. Up to 10% you can. Imagine project cost is 100 crores. 10% is 10 crore. Even 1% is a 1 crore. Even 0.1% is a 10 lakh rupees. Similarly, if you're not complied, then up to 5% of the project cost can be levied as a penalty. So even 0.1%, 1%, half percent also huge. I think West Bengal has levied a penalty of, I think 25,000, 50,000, 1 lakh rupees for non-filing the quarterly updates. Karnataka is levied for each quarter 10 lakh, 12 lakh rupees as the penalties. Please advise our builder clients, landowner clients, please follow this filing. We are there to support you. Need not to worry in terms of compliances, and we are there to support. But once the penalty is levied, it's difficult to get it quashed. So these are all the various other aspects as part of as an audit. I have a Godrej. Godrej has a multiple businesses. Like they have consumer, they have investment, they have Godrej Fena, they have real estate. Various divisions are there. Business wise, location wise, project wise, RERA phase wise. So if every business is in the same entity, then your audit is furthermore challenged unless they have maintained the separate books of accounts. So these are all the people always look at uniformity of information, your GST and RERA, income tax and RERA, bankers and RERA, lenders and RERA, books and RERA, investors and RERA, RERA themselves. One quarter you file something, another quarter you file something. Companies Act. In case of a delay compensation, RERA says about SBI MCLR plus 2%. In case of a delay, certainly it's a crystallized damages. You have to provide in the books of accounts. That is what is important aspect of it. And the accounting standards is important for that. So these are all the other aspect to it, and to whom all RERA is required. If you think that RERA registration is only for the purpose of customer, no. Basically, it's for protection the builder himself. RERA is mandated by legislation, no escape. Every banker who release a loan need a RERA. Lenders to fund the project require a RERA. Buyers to purchase the unit require RERA. Insurance companies asking. Agent to market the real estate project require RERA. Even vendors to supply the materials on credit, they also request the RERA registration because they're supplying on credit. If tomorrow something happens to the project, then their claim is at stake because RERA itself is not registered. Then what is the fate of that? And also your planning authorities to release the completion certificate, they also require RERA. All along what we felt is only customers require RERA. No, entire ecosystem of this industry require a RERA. That's what is important. In view of all these things, who is the first person to come forward to take RERA? Is the builder. That is what is important aspect of it. So various other aspect in terms of the impact of RERA on the real estate sector, something is this. Okay. So this is what is the books which I have told you. One is on the Maharashtra, another is the Karnataka RERA. You can take it in the taxman publication which is available. So that's all is my presentation, friends. Thanks for your patience hearing, and I know that many of you have posted the questions. Questions are open. You can switch on your cameras or videos, and you can ask any question. So I got a question from Chartered Accountant stating that precautions about CA certificate while issuing the certificate. Very good question. Probably I've covered few of the things. Still, I wanted to say, in terms of number one, don't be casual about while issuing the certificate. Number two, understand RERA before issue the certificate because Again, I'm insisting, again, I'm telling, because of our certificate, the money in the bank account, which is collected from the allottees, it is a allottees money, is taken out from the system. If that money is not used for the purpose it is meant, then I'm also responsible. So that is an important aspect of the CA certificate under RERA. Understand various components of RERA. More so, do not issue any CA certificate unless the books of accounts are maintained by the builder. Very important, friends, because we see that small and medium builders, they don't maintain the books of accounts properly or maintain it in a way that it is not, which is required, and do not issue certificate unless you satisfied about the maintenance of the books of accounts. That is what is the importance of CA certificates and relevance of CA certificates under RERA. Shashank ji, you have anything? Mahendra ji, Akash, Priya madam, anything about legal? Sujata madam, namaskara, namaste. Thank you to.
Sir, I have a question.
Yeah,
Sir, I have a question. Sir, suppose if our project completion date is 31st March 2025, we have submitted the quarterly returns till October. Sorry, till December. So we need to submit the quarterly returns. Thereafter, we need to submit the completion certificate, sir. How is
when is
it?
the completion?
Completion certificate if it is 31st March.
Okay. And for 31st March, you file the quarterly updates and you submit the completion.
Quarterly.
Yes.
Then we can submit the completions, huh?
Yes.
Okay.
Because in the completion
Okay.
certificate, completion filing, you have something about 100% completion.
Yeah.
Till you file 100% completion,
Sorry. Hello.
in quarterly update, you will have 100%. The moment you press 100%, then only your completion module open.
Correct, sir. Correct.
Yeah.
Yeah. So only okay.
Yes.
So that particular date is not relevant because we will be filing. Hello.
Yes, tell me, ma.
Sir, we'll be filing this quarterly report only after we'll have time from April 1st to April 15th, sir.
Yes.
That's the reason I'm asking. And the project completion will be 31st March.
Oh, project end date is 31st March, according to you.
Yes.
Okay, okay. Probably then, my recommendation is you file it on 31st itself. I'll take you this question off the line because there is a slight technical aspect, glitches to it in Karnataka. I will explain you off the
Okay.
record, Priya. Okay? Yeah.
No, oh, no problem. No problem, sir.
Thank
Yes.
you. Anything else?
Thanks.
Anybody?
Sir,
Okay.
myself, Mahendra here.
Yeah, Mahendra.
So I have two query regarding this. One, in Karnataka, there is a requirement of to open three bank account, 100%, 70%, 30%. So 70 and 100, and since all three accounts need to be open, it's respective that location itself of that project where it's situated. So 30%, whether we can use of the corporate account or is it required mandatory as per the act or as per the rule from bank itself for that particular project?
30% can be any account. There is no mandate, there is no compulsion from the authority in terms of what to use, where to open this account. 30% can be anywhere. But generally, authority says that you open this account also in the same place where you have the bank project located.
But it is not compulsory, it is optional, we can say. Correct, sir? Okay. No, okay, got it, sir. Second point, actually, during the project life cycle, let's say actually at the time of the RERA registration, we have declared 100 crore of that particular project cost, including land cost. And during the life cycle of the project, maybe the commodity price has gone down, labor rate has gone down, or maybe decrease, increase, whatever. So that project cost 100 to become actually 110. So whether how to report or update, is there any charges or is there any mandatory requirement to update at RERA portal, or how we have to do?
So in Karnataka, you do not have that option. Other state you have it. And one, we should understand what we have given is the estimated cost only. Estimated cost cannot be the accurate cost.
Correct.
It's okay to spend 110% or you okay to spend 98%. So there is no option for us to change it. And chartered accountants who issue the certificate should not change this estimated cost unless the authority allows them to change it. That's what is very important. You should remember, because many a times CS will keep changing this number to that number to this number. They should not change it. Yeah.
But it is a practically happen, sir. Actually,
That's
100
okay.
has
You
become
spend
100.
it. See, Mahendraji, it's a estimated amount. You spend,
Okay.
no issue for you. You can spend it, you can withdraw that. Okay. There's no challenge for you to withdraw it. Okay.
Yes, but
Yeah.
can't we change it RERA portal also in Karnataka?
Then
Because
that
it
has to
gives,
go through a big process of filing the application for change of the estimated cost, engineer details, engineer certificate. How did you increase it? What is the variance? Reason for the variance? Technically, how to explain?
okay.
That's not a smooth. Maybe we can try it if your company is really required to change it. Okay. Yeah. Fine.
Thank you,
Sir
sir.
Abhishek.
Welcome. Yeah. Abhishek.
Sir, in case of joint development between a builder and a landowner, we registered the project as a whole, correct? You just told that we can only register the builder share. It is not possible like that, right?
In Tamil Nadu, you can do that.
Okay.
Tamil Nadu, you can do it where authority clearly mentioned that only builder share is registered. Landowner shares should not be sold.
Okay. But in case if we register the project as a whole and the owners share, they will sell their share, they will receive the money. Like, how is that procedure? That also needs to be routed through our company account only, everything.
Yes, it is a project account. It's a
Okay.
project account.
Okay.
The moment project is landowner and developer, both money should come to this account only.
Okay.
In the Abhishek, you're from where? AP.
Yes, Telangana, sir.
Telangana. Okay. Probably Telangana has not given any directions to that. For Karnataka, you read the bank account direction where they have given a clarity. Money should come here and there should be a separate arrangement between them in terms of how do they operate their account. Okay.
Because okay. Okay, sir.
Anybody has any?
Yeah. So one more last question, Mahendra here. So as you mentioned during the lecture, actually saying that it just, if any project has taken the loan from the bank, that has mandatory to deposit into 70% account.
Yes.
Okay, but loan means actually, let's say the project has been hypothecated as a receivable, future receivable, hypothecated, but not mortgage actually. So
Whatever may
in
be.
case of the hypothecation also required to be
Yes, where you have created the encumbrance, yes, you should do that.
okay. But
Yeah.
sir, let's say actually recently I acquired the land, and then actually on the base of the debt, actually a future receivable, I hypothecated that and taken the loan. But still, the RERA is not yet registered. 70% account is not yet open. Then
There is no
how
alert is at this point of time. But you utilize that money for the acquisition of land
for other
only.
project, correct?
Then
So
that's
how?
okay.
That's okay, na? Okay. Once I'll launch the project, post that actually I have to, whatever that I'm taking the loan, that I have to deposit into 70%.
RERA account. Yes.
Okay.
Sir, in case we directly register the what do we say, owner's share in his name only and don't receive any money, then I don't think this aspect comes out, right? Because if he doesn't give any money for his share, we register it in his name, the land. Then
No, you are talking about joint development.
yes,
Joint development, obviously, either you can go with the area sharing or the revenue sharing.
yes.
Revenue sharing is of no problem. Area sharing, yes, whenever he sells, the money should come in this account.
Okay.
Yeah.
Okay.
Any other queries, friends? Okay. Thank you so much. And very nice of you.
Thank you,
Be
sir.
here on the working day and 1.5 hours spending on this subject topic of hearing. Probably from my office, you will get this PPT. You can go through. My contact details are there at the end of the presentation. If you have anybody has any question or details or clarification, you are free to revert back to me. Thank you so much. Thank you. Thank you.
Thank you, sir.
Thank you, sir.
Yeah, thank you, RERA consultants, and also Opaza and Naredko for hosting this, the series of the program for a real estate month on month. Friends, if you are keep watching, observing, we'll have a month on month session on the real estate, maybe RERA, GST, income tax related to that. Okay. we are coming out with the latest updates on the real estate and various aspects to it. Thank you so much. Okay. See you
I
next
thank
time.
Dinesh sir
Thank you.
for giving their valuable time and educating us on real RERA latest updates. I also wish to thank all the participants today for patiently participating in this session. Hope the session was informative and knowledgeable. If you have any queries, please do contact us. Thank you. Have a nice day.
Thank you, sir. Thank you.
Thank you. Thank you.
Thank you, sir.